Well, we'll get started. It is my great pleasure to welcome you to the fourth and the last colloquium in our series for this fall semester. And today's topic is from the area of humanities or social sciences, whichever way you want to call it. It is at that intersection. And we have already lined up a very nice set of speakers for the spring semester. And Linda is working on the brochure, and the brochure should be ready shortly, and we will mail them out and we will send emails. So we are going to have a very interesting set of speakers for the spring semester. As usual, it will be on the second Tuesday of each month, starting from February. And it won't be here, it will be, we'll go back to our naval architecture building where we have a lot of wood and everything else. And it is my great pleasure today to introduce Mr. Thomas Graff, who is the Regional Director of Environmental Defense. They are very prominent, very active, and a very influential non-governmental organization which has played a very important role in influencing water policy and transportation policy in California. Mr. Graff was educated at Harvard, where he got his bachelor's degree, undergraduate degree, as well as his law degree. And he was also educated at the London School of Economics. Following that, he worked for some time as a clerk for Justice McGovern of the Circuit Court of Appeal from Washington, D.C. area. Then he also worked for a legal firm. And in 1971, he made a major shift in his career. He came to California and founded in 1971 the Oakland office, the California office of Environmental Defense. Ever since, for the last 31 years, he has worked very hard with great enthusiasm towards water conservation in the West, not only in California, in the American West, as well as more equitable and efficient transportation policies. And today he is going to reflect. I requested him especially to look back on his own career and then survey what has happened in the last 30 years, what have been the successes and what have been the shortcomings or failures of this environmental movement, which now, in addition to the three arms of the government, has informally become the fourth arm of the government in influencing policy. Mr. Tom Graff.
Wow. Lord. Thank you all for coming. I want to thank two people particularly for coming. My wife Sharona up there and my daughter Rebecca, who's a freshman here at UC Berkeley. And also several other friends that I see here and there. I'm sorry to embarrass them. Today happens to be a particularly exciting day. California water generally moves very slowly, but in the last 24 hours there have been three significant developments in California water. I'll try and touch on them as I go along. Just to mention them at the beginning, some of you may already have read that last night in a historic and somewhat surprising decision, the Imperial Irrigation District voted 3-2 to reject the package of agreements that had been negotiated and were supposed to bring all the California parties together on a combination of schemes that would lead California over time to reducing its water diversions from the Colorado River. And its failure to do that at least raises the specter that within 3 weeks, the Secretary of the Interior is to announce that California would abruptly lose something like 700,000 to 800,000 acre-feet of water in the year 2003 and thereafter, in the absence of agreements on how to reduce that set of diversions in a systematic way. Secondly, although it's not announced yet, it was a presentation was made to a federal district judge in Fresno this morning that on Thursday the United States will submit to the district court a settlement agreement with a group of landowners on the west side and east side of the Westlands Water District and the Valley Trough, who are the area most heavily impacted by salinity and selenium contamination. The terms of that settlement are not yet publicly known. I might mention as I go along a few thoughts we have about that, what we think is in that settlement, some good things and some not so good. And then thirdly, a decision was rendered by that same judge actually today in litigation involving the Trinity River, filed by the same Westlands Water District and other agricultural interests, as well as a group of public power interests, including Sacramento Municipal Utility District and the Northern California Power Agency, which represents, among others, the cities of Santa Clara and Palo Alto and Alameda, and even the Port of Oakland and BART, all of whom, by the way, are seeking to reduce the amount of water that is allowed to flow down the Trinity River for the benefit of fisheries and the fishing and cultural interests of the Hoopa tribe on the Trinity. So I'll come back to all of those, but I thought I'd at least let you know that things are happening in the water world, even as we meet here today. I have two sort of themes. The second one somewhat related to what I was asked to speak about. The first is to talk a little, and this, last night I watched, for those of you who are coming to all the series, I watched Ron Roby's presentation from 2 months ago. And he touched on a lot of these as well. I'm going to talk about, and this is my attempt at being intellectually interesting, the tensions between the public trust and water markets. As I'll come to in a while, water markets are something that Environmental Defense and I personally have advocated over the last 20 years or so, as we've also advocated in many situations, both for the formal public trust. Joe Sachs here, noted professor, is one of the sort of intellectual explicators of that doctrine, but it can also be more broadly defined as the public interest and advocating directly for public values as against economic interests on the other side. The other tension, less intellectual one, is and somewhat more directly involved in my profession as a lawyer, is the tension between acting confrontationally and acting cooperatively. Again, Ron Roby in his remarks talked about that tension, deplored litigation generally in his remarks, and I think even in a question and answer period referred to me as a monkey wrencher. So, so you can make up your mind as we go along whether that's accurate and appropriate. I will say that tension, and I'll mention that one thing I'll try to do is personalize this a little bit and talk about some personalities that I've encountered along the way in the last 30 years. The Albert Einstein bumper sticker, "One cannot prepare for war and for peace at the same time," is one I've thought about a lot, and I think I disagree with Einstein, which is probably dangerous. Okay, so I'm going to start from there. I know I'm supposed to speak for 50 minutes to an hour, so I'd actually prefer it if people get excited to have them raise questions and interrupt me as we go along. But if you don't, I'll just keep speaking. Okay, a little bit of this talk will be adapted from a talk I gave a year and a half or so ago at the University of Colorado. That was more of a legal talk, so I get too legalistic, also kind of look uncomfortable, and I'll try and be more oriented to a lay audience, although I'm sure many in this room are much more knowledgeable on some of these issues than I. When I started in environmental law, and particularly in water law, in the early 1970s, the seminal document was the report of the National Water Commission, which was published, I think, in 1973, and was chaired by Charles Luce, who had been Bonneville Power Administrator. The occasion of that commission had been the authorization of the Central Arizona project in legislation in the late 1960s, and the advent of the CAP and of earlier projects such as Hoover Dam and the All-American Canal serving California was perceived in the Northwest as a threat to the states of Washington and Oregon. So as a partial sort of sop to the Northwest, and particularly to Senator Scoop Jackson of Washington, who was a powerful figure at the time, there was an agreement to create a commission that would look into different ways of addressing water problems than simply building these large dams and canals and conveyance systems as means to get water from one place to another. And Luce, coming from the Northwest, was appointed as the head of that commission. But among those who were staff to that commission and who I think wrote commission papers for the commission and who ended up writing learned articles thereafter were two law professors of great note, and really some of the sort of seminal minds in this area. One is your own Joe Sachs, who at the time I think was at the University of Colorado, moved to Michigan and then here, and the other was Charlie Myers, who was at Stanford, later became dean. And they actually had quite different points of view, which kind of informed what little thinking I think I was doing at the time. Joe was, as I've already indicated, a great proponent of the public trust and of forcing environmental values into public decision-making, particularly water-related public decision-making, although not exclusively water. And his great contributions, I think, were in forcing a system of water allocation and development which had pretty much ignored environmental values up to that point to actually begin to consider them. To Myers, the principal issue that he was addressing was waste, and mostly economic waste, although he had environmental interests as well. And what he saw in the great subsidized development of the West, of water projects of which the CAP, the Central Arizona Project at the time, was the most recent large example, was bad economics as well as environmentally threatening activity, and his solution was water markets, or at least his principal solution was applying economics to the allocation of water. And so, I mean, one of the great privileges, I think, of my legal career, which is, I think, rare actually among lawyers, is that although there is a formal structure and a litigation review committee and various things that the people that I did and do report to, I had a fair amount of freedom, as did my fellow staff members, in sort of selecting cases and approaches and strategies for how to address the major environmentally related water issues of the day. And so it was really with those two kinds of approaches, the Sachs approach of public trust and the Myers approach of water markets, that we sort of launched our activities in the 1970s. So I'm going to talk a little bit about some of those early battles of the 1970s. I see a fair number of young people here. Some of these will seem kind of unknown, may well be unknown to you. Others will remember them as quite major and important battles. The first two I thought I'd talk about were battles over the construction of two dams, the Auburn Dam and the New Melones Dam. Both were authorized by the Congress, one New Melones to be built by the Corps of Engineers and the other Auburn by the Bureau of Reclamation. By the time we got involved with those two projects, they had been authorized by Congress. They were in the early stages, either certainly had been designed or in the early stages of construction in I guess both cases. And yet my colleagues at the time and I decided to plunge in and take them on anyway. One of those colleagues is probably known to most of you, was Jerry Merrill, most recently the author of Proposition 51 on the November 2002 ballot. And I still remember actually as one fun set of stories was in the middle of the energy crisis of the, I guess it was middle or late spring, summer of 1973, the oil boycott of the time, driving up and back to a federal district court set of hearings in Sacramento before Judge McBride, with Jerry and with John Leshy, representing Natural Resources Defense Council at the time, later Solicitor of the Interior for 8 years in the Clinton administration and now a professor at Hastings. Also involved tangentially, although not joining us at times. Phil Williams, by the way, was also involved. Phil is a noted engineer, later was the principal engineer for environmental interests in both the Owens Valley and Mono Lake cases. But John Bryson was also involved as an NRDC lawyer on Auburn and the American River at the time. John later rose to be and is still the chairman of the board of the Edison Corporation. Anyway, those are the one thing we learned was we could buy gas at on Interstate 80 even when it wasn't available locally here in the Bay Area. So we got up there and back pretty readily actually to the trial. We had some successes, but ultimately legally we lost those cases. The environmental impact statements that were filed on those two big projects were in the very early days of NEPA, the National Environmental Policy Act, and they weren't very good. So we got injunctions in one case from Judge McBride, in the other case from the Court of Appeals. But ultimately, the government got better at writing EISs, and we lost the legal cases. But at the same time, we were also involved in proceedings before the State Water Resources Control Board in the days when that board actually still took aggressive action. And in both cases, the board approved permits to divert water, which was what the federal government was asking for, but with significant conditions attached. In the case of the American River, it was flow conditions downstream. In the case of the Stanislaus River in New Melones, it was even more stringent conditions. It basically said you can build the dam, but you can't fill it until you come and demonstrate to us that you have a set of uses for the water that you would store behind the dam. Needless to say, the United States was not pleased by either of those sets of conditions, particularly the latter, and they contested them, claiming lack of jurisdiction on the part of the state. And those two cases, plus another involving a similar but somewhat more complex set of conditions on the operation of the whole Central Valley project in the Delta, resulted in a series of cases going to the U.S. Supreme Court in the late 70s, 1978. The seminal case of United States v. California was announced by the Supreme Court that year, and it really established that the United States was indeed subject to state water rights jurisdiction, and with the only caveat to that being if there was explicit language in the congressional authorizations for the projects involved, that those could override the general state authority. But in these particular cases, there was no such explicit override, and so remarkably, actually, the state's jurisdiction was upheld and the state's regulations were upheld. And that was actually quite remarkable set of achievements. It was largely the work, actually, of Republican administrations, both at the gubernatorial and board level. In those days, Ronald Reagan was governor of California, and Evel Younger was attorney general. And they contested both Republican and Democratic administrations in Washington. In fact, at the time of US v. California, Jimmy Carter was the president. So we learned, actually, in those cases that we could work with a variety of political interests, including those perceived to be conservative, and could make arguments, in addition to water marketing kinds of arguments, that were on the conservative side of the spectrum, states' rights being the obvious one here. Third case of note from those early days, again, this is sort of a lawyer's environmental advocate story, was a suit that I was the principal attorney on against the East Bay Municipal Utility District, which we filed in 1972. And like Jarndyce v. Jarndyce, continues to this day. That's a little bit of an exaggeration, but not much. Jurisdiction is still pending before Superior Court Judge Hodge, who actually issued the major decision in the case in the early 90s, only 20 or so years after it was filed. But there were some fun interludes in the meantime. I got the opportunity to argue twice before the California Supreme Court in that case, and it provided me with my one and only U.S. Supreme Court victory. But they didn't bother to hear what I had to say. They simply remanded in light of U.S. v. California, sending the case back to the California Supreme Court, and said to the California Supreme Court and Justice Clark, who had written the original opinion, that state law could govern in a dispute that we had with East Bay Mud. The issue before the courts was whether East Bay Mud's proposed supplemental diversion from the American River. We get our water here from the McKelvey. It wanted additional water from the American, and we argued two things, really. One, that it was unnecessary and it was a waste and unreasonable use of water to take a supplemental supply at all. And secondly, if it was to be taken, it should be taken downstream so multiple use could be made of the water on the American River. We were joined by Save the American River Association and the County of Sacramento in that argument. And the Supreme Court, California Supreme Court, had originally held that because East Bay Mud was taking the water from the Auburn-Folsom South federal project, federal law controlled, and therefore state doctrines of unreasonable use and unreasonable diversion didn't apply. The U.S. Supreme Court disagreed and again said, in the absence of explicit federal law to the contrary, state law could apply. So we eventually went through board proceedings, court proceedings. Yes?
Because one would normally think that both the federal government and the state government have a common interest in using the natural resources for our benefit of all. How come we have, for the layperson who is not a legally inclined, it's kind of baffles the mind how the state government would say that this is beneficial, and the federal government should see the benefit in a totally different way. How can one philosophically or otherwise justify or rationalize that?
Can everyone hear the question? Yes? The question was, how can the state and federal government see the issues in such different lights? And I mean, I don't have a full answer to that. I think they were, to some degree, responsive to different constituencies. The tradition of public works authorization and construction going back to the times of the New Deal. Mostly Democrats, by the way, have built large public works, not Republicans. Was still prevalent, and the congressional committee system and seniority system resulted in major congressional support for some of these projects. In the case of Auburn Dam, Congressman Biz Johnson, who ultimately rose to be chair of the Public Works Committee. In the case of New Melones, it was Congressman John McFall, who became majority whip for a time. And they had enough political clout with their colleagues to push through projects that had, from my point of view anyway, shaky justification. At the state level, I guess the environmental winds were blowing in the early to mid 70s, and the water board at that time, Ron Roby, of course, was one of the members. Gene Auer, another distinguished person who had been put on the water board largely because of a prior scandal, and Governor Reagan was looking for someone with impeccable credentials. She had been a leading League of Women Voters water policy expert, was brought to the board. And they took, they just saw the case on the merits and of course ruled for us. No, that's a slight exaggeration, but I think they were more responsive to that set of concerns, and were not beholden to the congressional construction company beneficiary complex who pushed through authorizations. I will say that there was a ballot measure, for those of you who followed the politics of the time, in 1974 that sought to essentially to deauthorize New Melones, save the Stanislaus, Proposition 17. It was really the start of Jerry's career as a initiative advocate, and that proposition actually had, at least as the polls showed, public opinion polls showed, had majority support among the voters of California, but it was defeated in the November 1974 election. Interesting enough, it was the one issue on the ballot that really separated the two gubernatorial candidates of the day, Jerry Brown and Houston Flournoy. I still remember taking Jerry Brown down the Stanislaus River. He didn't really like it much, although he came out for the river and against the dam. The reason I say it was supported in the public opinion polls but not voted on by the public is that the no campaign had the much larger budget, mostly supplied by Guy F. Atkinson, who had the contract to build the dam, and they basically obfuscated the issue. They said that people were voting thinking when they voted yes, they thought they were voting yes to save save the river, and no was against the dam, when in fact it was the opposite. I think I might have just confused that. But anyway, enough people voted the opposite way from what they were supposed to that we lost the election. I don't know if that's responsive to your question, but there's a current example. It's not a water example. The president has announced that he doesn't think we should act or legislate in the area of climate change and greenhouse gas reductions. And just this last summer, the California State Legislature passed an important bill to do just that, to regulate Detroit, auto companies, both domestic and foreign, to reduce their greenhouse gas emissions. So it's not that surprising, I think, that state and federal governments have differences of opinion. And it's shifted over the years. The 70s, I think, were years when the state generally was the more environmental and the federal government less, but that did shift. Jimmy Carter, when he was first elected president, announced a hit list of water projects. Those of you who remember it, one of the architects of that was a former colleague of mine, a young woman named Kathy Fletcher, who now is the leading advocate of water pollution control up in Puget Sound. Auburn was on the hit list. Unfortunately, by the way, San Felipe Division, which we were trying to stop at the time as well, which is a branch of the Central Valley Project that now serves Silicon Valley, was not on the list, and I think that was one of the reasons why ultimately a federal district judge in San Francisco ruled that it could proceed. Interestingly, in terms of the sort of personalities of water, one of our witnesses in that case was Harvey O. Banks, name used to be very famous in California Water, and he was really the engineering architect of the state water project, was director of water resources under both Republican Governor Knight and later Democratic Governor Brown, although only briefly, and Pat Brown, and was responsible really in large measure for getting the state water project built, but he also testified for us in the San Felipe case that additional diversions from the Bay Delta estuary could be environmentally harmful, and that the documents of the federal government setting forth the consequences of San Felipe Division construction were inadequate. Unfortunately, we lost in that case. So most of these cases that I've been describing are traditional environmentalists go up against the big bad guys. The only slight twist on this in the water field is that most of the adversaries are public agencies rather than large corporate interests. And I'll just go to one last case and then move on to water markets. The last important case where I barely played a role at all, but was kind of an occasional consultant, was the quite famous Mono Lake case, National Audubon Society against Superior Court. And it involved directly the public trust doctrine being applied to diversions from the Mono Basin to Los Angeles. And ultimately, not ultimately, the California Supreme Court held that despite having what seemed like vested water rights that had been granted in the 40s or maybe even earlier, and a license for which I just heard Ron Roby say finally been completed in the 70s. Those rights could be reopened, and an adjudication really was launched to see whether, in light of the public trust interest in the preservation of the streams in the lake, those rights could be essentially revoked or at least reduced. Ultimately, after many proceedings, really the last major significant environmental case really that the Water Board, environmental water rights case that the Water Board has issued, the diversions from the Mono Basin were reduced, and Mono Lake is indeed being restored. Interestingly, there's a sidebar to that. A colleague of mine, Zach Willey, and I were involved in a consensus-based process that was sponsored by UCLA Extension and run by a fellow by the name of Leroy Gramer, who later came up here to Berkeley. And a product of those lengthy and somewhat tedious actual discussions was a series of alternative measures that Los Angeles could take to replace the Mono Basin diversions. Some of those, particularly the water conservation and wastewater reclamation opportunities that were available in Los Angeles, became the alternative that Los Angeles actually pursued, and with considerable financial assistance of the state and federal governments, Los Angeles is now as well endowed with water supply as it was in the days when it was diverting from the Mono Basin. Indeed, even it's been reduced in its diversion somewhat from the Owens Valley as well. So it's not quite as simple as saying the environmentalists went after it and won. It was also the environmentalists went after it, and they and others promoted alternative solutions for the interests that were antagonistic to the environmental claims. And that's really what the sort of water marketing, is that a hand?
Yeah. I'm just wondering if you thought that the case for public trust in Mono Lake could be extended to the Salton Sea.
I'm going to get to that. Can you wait a little while? Is that okay? Okay. The case for water marketing from an environmental perspective is twofold. One, that as the population grows and water needs, requirements, desires, demands grow, there needs to be a supply to meet that demand. And in the conventional way of addressing that need had been to build new dams and new canals and new conveyance facilities, most of which, if not all, had adverse environmental consequences. So were there better ways of meeting those needs than to build more projects? And we looked around and basically said, well, let's see if we can buy water from those who currently have rights of one kind or another, get them to conserve their use in one way or another, and sell or lease. In 1983, we published a report entitled Trading Conservation Investments for Water, a proposal for the Metropolitan Water District of Southern California to obtain additional Colorado River water by financing water conservation investments for the Imperial Irrigation District. Nowadays, what used to be Environmental Defense Fund is now Environmental Defense, would never allow us to do a title of a report that long. But nobody was checking in those days. We didn't have the image police. So that report was published. The principal author was Zach Willey, kind of supervisor, but the principal author of that report was Rob Stavens, then a kind of a sort of graduate student who later rose to be a professor at the Kennedy School at Harvard and a seminal thinker in this field in his own right. In fact, he was then already. Mike Hanneman, by the way, just sent me an email yesterday. I guess he was originally going to introduce me, and he said, I can't do it. I've got to be in Stavens' class in Cambridge, talking about climate change and California water. So the economists have been water marketers, and arguably the water marketing, it's not like it was a new idea or that we had the idea first. It was a major part of the, as I said, Myers' thinking in the National Water Commission report. It was later a seminal piece of the Water Law Revision Commission reports of the late 1970s, commissioned by Jerry Brown, and of which former Chief Judge Wright was the chair. Hap Dunning, UC Davis law professor, was the executive director. But it was those ideas were largely kind of on the sideline, being ignored until the Great Peripheral Canal referendum fight of 1982. And Bob Gottlieb's sister, who is in the room, Bob was a dissident Metropolitan Water District director at the time. A hearty few souls from Southern California joined with many in the environmental community and some large agribusiness forces to referendize the bill that would have authorized the Peripheral Canal and a large group of associated water projects passed by the California legislature in 1980. The referendum actually took a long time. It was a year and a half of campaign, because by the time the bill had passed and it was referendized, it was too late for the November 80 election, so it took all the way till June 82, and there was a campaign that was roughly equal in expenditures on the two sides, as major economic forces were aligned against one another, and that fight, I would say, was the sort of demise of the old way of doing water policy business in California and really in the West. There really has not been significant, large, state or federally subsidized water project construction since 1982. Now it's starting maybe to come back, and I'll come to that. But it really did set the old way of doing business back. I mean, the water industry, such as it is of the time, was quite devastated by the defeat of the Peripheral Canal. So then along came, what do we do now? And that was the occasion of our publishing Trading Conservation Investments for Water. And we said, okay, if Southern California needs additional water, why not go buy it? And of course, one of the places to buy it, the biggest place, the place that has water rights of somewhere between 2.5 and perhaps 3 million acre feet, was the Imperial Valley. I still recall the meeting that Zach, Willie, and I had in Los Angeles. We flew down to MWD with the final draft of the Trading Conservation Investments for Water report and placed it on the desk in front of the then Assistant General Manager of MET, Dave Kennedy, and the General Counsel, Carl Baranke, and said, we would like you to review this before we publish it. And they both visibly pulled back and refused. They didn't want to touch it. So we ended up publishing it without their commentary. And they initially denounced it. Actually, shortly after that, Dave Kennedy became Governor Duke Majan's Director of Water Resources, was in that position for 8 years. Carl eventually became General Manager. And to his great credit, within a few years, changed his mind and helped move the MWD into a pro-marketing framework, and indeed signed the first major long-term water marketing agreement in California with IID, the Imperial Irrigation District. I'll come back to Carl later. He was also involved in the story of the Miller-Bradley bill in 1992. Maybe since you asked me about the Salton Sea, I'll give you a little preview on that as well. We ignored the Salton Sea in our Trading Conservation Investments for Water treatise in 1992. It's not fair to say in 1992. We didn't really ignore it. What we said was that there was a trend of increasing salinity in the sea. At that time, other contaminants were less of an issue, or at least were not publicly perceived as an issue. And all the transfer of water from Imperial to Met would be to accelerate that increase in salinity. And it was up to the public to decide if it wanted to do something about that, fine, but it was merely a matter of timing. I mean, in retrospect, we probably could have been a little more careful about that. As it turns out, there's a real debate, I mean, both legal and policy debate about whether the Salton Sea should be protected by the public trust doctrine. It's, after all, an artificial body of water. It's a drainage sump. It's a big drainage sump. But it is the artifact of irrigated agriculture in the desert and of a redirection of the Colorado River originally in the early part of the last century, in 1906, 8, something like that, 05, when a levee broke, I guess a railroad levee broke, and the Colorado River, so for two or 3 years, flowed into this very low elevation, sea level elevation in the middle of the desert. And it's been sustained ever since at fluctuating levels by agricultural drainage return flows, both from the US and Mexico. And salt comes in and salt doesn't go out. Water evaporates. So over time, the salinity has gone up and up and up and up. So the only fish that are still propagating there are introduced species. Of course, they were introduced because, well, I shouldn't say of course, they were introduced. The leading one is the African tilapia, actually. And they do provide, those fish provide a food source for migratory birds, but somehow imagining the courts, particularly in the face of the economic interests that are on the other side, saying that those are public trust resources that need to be protected, I don't think the fish would be. Maybe the birds would be. I don't know. It'll be interesting to see. There is litigation filed by some environmental organizations on the Salton Sea already. There's the additional environmental complication that if one looks at the ecosystem as a whole down there, the potentially more valuable and also heavily degraded, but at least more easily, at least from a physical point of view, restorable ecosystem is the Colorado River Delta in Mexico at the northern end of the Sea of Cortez. And it would only require 2 countries and a couple of states and a couple of provinces to sort that out. But it would, there is certainly a concerted effort of which colleagues of mine at Environmental Defense are very active to try to address the problems of the Colorado River Delta. I mean, considering, Peter Glick once said this to me, and it sort of kind of stuck, the amount of effort and attention that's been given to the San Francisco Bay Delta estuary has been enormous. The amount of attention until very recent years given to the Colorado River Delta has been almost none at all. Yet for two large periods of time, basically the construction of Hoover Dam, and then once it was built and filled, and then later at Glen Canyon Dam, the river was basically dry. And even now, we promise as a country to give Mexico 1.5 million acre-feet per year. Sometimes there's a spillover of an extra couple 100,000, and very little of that gets to the Delta. Still, if one were to imagine comity between the two countries and the interests in the basin, and financial and physical and scientific resources to bear, to be brought to trying to restore ecosystems in that area, it seems to me the Delta is probably the more the better ecosystem to address. Yes. Sorry. Okay. So the Peripheral Canal was defeated. Trading Conservation Investments for Water was published. The agencies of government slowly started to take water marketing seriously. It's still a sometime proposition, and it's a complicated and difficult thing to do to make markets work. But it is certainly within the ideology of conservatives and Republicans to embrace markets. And it ought to be in the interest of Democrats and liberals to support measures that protect the environment and that forestall other environmental insults. So there has been progress on water markets since the early 80s. Thought I'd tell one other little story and then move on. In light of my comments about Westlands and the land retirement settlement that will be announced day after tomorrow. In the 1980 presidential campaign, Cecil Andrus had been Secretary of Interior under Jimmy Carter and was a strong environmentalist in many ways, and had been pretty good in trying to get the Westlands Water District, which is the largest of the CVP contractors, to constrain the amount of water it took and to address its drainage problems. Midway through 1980, Rosalind Carter visited Fresno, and shortly thereafter, Secretary Andrus changed his mind about the contract negotiation that was underway with Westlands, and offered what seemed like extraordinarily favorable terms from our point of view. And we protested mightily, and remarkably, actually, as election day approached, and the west side of the San Joaquin Valley saw what seemed like a likely Reagan win, the Westlands turned down the Andrus deal and thought they'd get a better deal from his successor. For those of you who have a memory, his successor was the infamous James Watt, and to everyone's surprise, ours included, Watt withdrew the Andrus proposal and offered a much less attractive alternative to Westlands. Shortly thereafter, Westlands was shocked and sued, and to the surprise of even more people, including many of our colleagues in the environmental community, we intervened in the lawsuit on James Watt's side. Well, actually, that's not true. We sought to intervene in the lawsuit on James Watt's side, and I guess not our surprise, both sides in that lawsuit, both the Reagan administration and the Westlands opposed our intervention, and the federal court in Fresno wouldn't let us in, which actually later turned out to be too bad, because within a few years, the political and economic power of the Westlands interests had overwhelmed even James Watt, and a very favorable settlement this is a recurring pattern, was assigned between Westlands and the United States. I might say one of interestingly, another figure that comes into this is Ken Kachigian. Those of you who are politically follow these kinds of things, he's a longtime political consultant to gubernatorial and presidential candidates on the Republican side. He's the lawyer for the settlers in the Westlands case for the farmers in the Valley Trough. And I just saw in the paper this morning, in the Los Angeles Times, he's now the lawyer for the Imperial Irrigation District in resisting what will surely be the massed forces of the rest of Southern California and the state and federal governments. Not a bad choice, probably, for IID. So we're moving through the 1980s, and a drought hits California in 1986-87 over a very short period of time, 3-4 years. What finally happens is what had been predicted by fisheries biologists for many years previously. The major salmon stocks, resident fish in the delta, particularly the delta smelt, crash and are threatened or endangered. Why? Because there are too many diversions from the delta south and too many depletions of water upstream as well. And the Endangered Species Act begins to be applied to restrict diversions and depletions and pumping by the two big projects. The projects are stunned. They're also worried that they can't get their contracts renewed. The Central Valley Project contractors are stalled by litigation. And in one of the remarkable political developments of my lifetime in water, maybe the remarkable political development of my lifetime in water, a bill passes the Congress to reform the Central Valley Project in 1992. Now, Malka over there has done a whole series, an oral history series on that bill by various interests of on all sides, both in the Congress and outside. A colleague of mine, David Yardis, and I got the wonderful opportunity to do one of those. So if people are really interested in the details, they're available in great quantity. But the short version, which was fun, was that California, the only reason the bill passed really at the time was that California had no senators. Now some might dispute that, but the reality is that Alan Cranston had faithfully represented the interests of irrigated agriculture in his 3 terms as senator. And so had Pete Wilson in his brief sojourn in the United States Senate. But Pete had just been elected governor. There was an appointed senator, John Seymour, in his place. Appointed senators who hadn't been elected have less clout in the clubby atmosphere of the Senate. Cranston had checked out because he was retiring, and he gave his proxy to Bradley. And so there was this window where, in the tradition of the Senate, one senator can block pretty much anything happening in his or her state. There's an exception to that. The Alaska Wilderness Bill is an exception. But there really are very few exceptions. But in this case, John Seymour didn't have the clout to stop the juggernaut coming from Bill Bradley. And I think the other side, really irrigated agriculture, particularly West Side agriculture, who opposed us, expected a veto from then President Bush, largely because Governor Wilson was actively pursuing it. But to their surprise, President Bush signed the Miller-Bradley bill. And the Miller-Bradley bill was essentially the apotheosis, is that the right word, of both the public trust approach and the water marketing approach. The reason it passed was not that environmental interests were for it, although that was probably significant. The real reason it passed was that the Business Roundtable was for it and the Metropolitan Water District was for it. And they were for it because it, for the first time, allowed Central Valley Project water, which was being sold at subsidized rates, to be resold to others. And Met saw this as a potential new water supply in Northern California, which had previously been inaccessible. And the Roundtable saw it as the right policy outcome, and they overrode the objections of their agricultural members. There were a couple, 2, 3 big business leaders, corporate leaders who really spearheaded that fight. Dick Rosenberg at the Bank of America, and most importantly, Jim Harvey, a fly fisherman at Transamerica. And there's a great story, actually, that after the bill passed and it was pending on the president's desk, the Transamerica board recessed. And the various members of the Transamerica board got on the phone and called Washington, then Treasury Secretary Baker and OMB Director Darman to lobby for the bill. Among those board members were luminaries like Peter Ueberroth, the head of the Olympics, and interestingly, Condoleezza Rice. So whether that's what turned the tide and got the president to sign the bill, or whether it was that the bill was also laced with pork barrel goodies for other states, and the 2 Utah senators were all over the president to get him to sign the bill, we don't really know.
Where is it now?
Where's the bill? Well, it's 10 years later. I actually sent a little email to Bill Bradley recently saying, well, you know, we haven't really done much with your bill. Essentially what happened was Bill Clinton was elected in, 3 days after the bill was signed by President Bush. I think President Bush, 4 days. I think he signed it on a Friday, and the election was Tuesday. And Bill Clinton made a political calculation that he didn't want to have a big fight over water with then Governor Wilson, and the rest of the 90s, or at least the next few years, were years of negotiation rather than confrontation. So CVPIA, which is the formal name, Central Valley Project Improvement Act, formal name of the Miller-Bradley bill, was lightly, I would say, implemented. I mean, another aspect, this goes back to the confrontation versus cooperation. The leading environmental defense fund advocate in those negotiations in those years was John Krautkramer, a wonderful colleague of mine who died prematurely shortly after that. But he was really, I would say, the most instrumental environmentalist in the negotiation of the Bay Delta Accord in late 1994, and it was really contrary to what had happened in the 70s, very different points of view were reconciled between Governor Wilson's administration and President Clinton's. In some measure, I think, because of the creative work and the right kind of personality that John brought to that set of discussions. Obviously, John didn't do it alone. There were comparable people representing urban and agricultural interests as well, and a very skilled bureaucrat, Betsy Reekie, who was the Assistant Secretary of the Interior at the time, who brought that deal together. Now, whether had John lived, there would have been more cooperation and less confrontation as developed thereafter, I don't know. I will say that it was in January 1995, 2 months after the Accord, well, 1 month after the Accord was signed, but shortly after the 94 election, in which Newt Gingrich took control in the House and the Republicans also took control in the Senate, that the West Side interests brought new litigation and proposed legislation both to amend CVPIA and to take over the operation of the Central Valley Project. So the era of good feelings overall lasted about a month. But it's at least plausible to think that I do think actually that personalities do matter in these kinds of negotiations, and sometimes accords of the type that the Bay Delta Accord was. And I really haven't described what was in it. It had 3 major components. It caused the state and federal governments to operate their 2 large projects in the Delta together, and to include other constituencies, including environmental constituencies, in the operations. It committed the state government, which had been dragging its feet for years to promulgate new standards of protection for the Bay Delta estuary. That was what the federal government really wanted from Pete Wilson. And what Pete Wilson wanted from the federal government was a planning process that would lead to a new water plan for California, which was then ultimately promulgated 6 years later, with two new administrations. Well, I guess with Babbitt still in power at the federal level, but with, by that time, Gray Davis and Mary Nichols in power at the state level, which has sort of, the so-called CalFed record of decision, sort of set a course for state and federal water policy into the future. Am I running out of time? Shall we go to Q&A? Let me just conclude with where are we going from here? A year or so ago, a year and a half ago, Terry Anderson, the head of a group called the Political Economy Resource Center, a libertarian, very pro-marketing group, and I wrote an op-ed in the San Jose Mercury in which we argued, which we criticized CalFed and the record of decision and argued that water markets and not taxpayer subsidies to water development should be the lead policy instrument in addressing California's future water supply needs. At that time, Senator Feinstein had just introduced her CalFed federal authorization bill. That bill struggled for a year and a half and mercifully died on the last day of the session just a month or so ago at the hands, interestingly enough, of Congressman Doolittle, Pombo, Herger, and Rudanovich. And I promised my friends in the rural counties that I would give them credit somewhere. So there is a camera here. But credit should be given where credit is due, and they were the ones who prevailed upon House Speaker Hastert not to take up Senator Feinstein's bill on the last day of the session, and so there is no federal CalFed authorization. So where do we go from here? I would hope three things happen. One, we continue to have no significant water subsidies for dam and canal construction. If they are to proceed, let those who would benefit from them pay. If those who would benefit from them pay, there will be relatively few built. The couple of examples of projects that have been built in recent times, Los Vaqueros here in Contra Costa County, was now called Diamond Valley in Southern California, were in fact built by a local agency, so it can be done. But the kinds of projects that CalFed would have built, which are nominally have nominal environmental benefits, ought to be paid for if they're going to be built at all by users. On the other hand, there should be serious consideration given to major restoration efforts of fisheries, for migratory birds, and for the Trinity River, and most importantly, and newly, in the last year or so, or newly again, the Hetch Hetchy Valley in Yosemite National Park, where the public benefits of restoring an aesthetic and resource and ecosystem, perhaps second only to Yosemite, are enormous. And if alternatives can be developed for San Francisco and other Hetch Hetchy system users, water and power, it ought to be done, or at least it ought to be investigated, and that's something that a colleague of mine, Speck Rosecrans, and I are actively pursuing. And possibly there's a deal, a dam somewhere else in exchange for taking down the dam, or at least emptying the reservoir behind Hetch Hetchy might be worth the deal. Secondly, water transfers will continue. IID's vote of 3-2 last night notwithstanding, from the desert valleys to the coast in Southern California. There's just too much economic and political power behind that. Will it happen in the next 3 weeks before the December 31 deadline? I don't know. If it doesn't, it's going to be really interesting. Does Secretary Norton really have the willingness to cut California by 800,000 acre-feet overnight? If she does, what happens next? The priority system would have IID get most of what it wants, and MWD get very little of what it wants? Is that really what's going to happen? If not, what will happen to make that not happen in the short run? I don't know. And if those priorities can't be changed in the short run, what that of course means is that Metropolitan will come north and will try to take more water from the Delta. And again, that will have repercussions among both environmental and other Delta diverters. And then lastly, back to land retirement. And I should have mentioned there is a cooperative approach to drainage solutions in the Central Valley. A colleague of mine, Terry Young, has been very heavily involved in the Grasslands area. But so far, those cooperative approaches have not been deployed in Westlands. But land retirement and other solutions to drainage, but not a drain to the Delta or to Monterey Bay, will, I think, over time proceed. They have to. And some public money is presumably going to be spent in addressing those problems and pursuing those solutions. But, and this is a telegraph of a position we're likely to take 2 days or 3 days from now, only if public benefits flow from that set of public expenditures. There's going to be a lot of money made by Ken Kachigian's clients 2 days from now if that agreement goes through, and maybe that's okay, but it's okay if also some water is returned to the environment, and if the pollution problems occasioned by irrigated agriculture on the west side are in fact addressed. So I skipped some stuff, but I went over, but here I am. Questions? I'm sorry. Yes, sir.
I just have two related questions. What's the percentage, proportion of the consumed water of California is agricultural?
It's probably now in the high 70s. For years, it was in the mid 80s, but it's sort of, as our urban areas and suburban areas have expanded, it's probably now in the, of the consumed water, it's in the high 70s. Just a quick footnote on that. That number used to be the one we would always say, and it's quite impressive. People kind of wake up. There are a lot of public opinion polls. You ask people, where do you think water's used? And you kind of give them the three major sectors: irrigation, urban, environmental. They don't know that. They think, oh, maybe it's 50-50, say urban ag. It's not, right? Sorry, second question.
Kind of a related question. If you could generalize about water rights, let's say, in person marketing, who generally owns the water that could be sold? Is there some generalities?
Well, ownership is a slippery word in water. I mean, land, personal property, things we wear are a little clearer. I mean, lawyers can play games with those too, but technically the ownership of water is in the state. The state then sets up an elaborate system for essentially giving away the water. And I think probably the fundamental environmental problem of water in the West is that water is given away. I mean, if something is scarce, you want to charge for it, and you want to make people value it, and yet the whole system has been to give it away, to the so-called first in time, first in right, appropriative right system, which is different from the old English system that prevails in the eastern U.S., is a system that encourages use. And that made some policy sense in the settlement period of the late 19th and early 20th century. It makes very little sense today when water is scarce.
Is there much water farmers, let's say, who've been using it for a long time, can they transfer it to some other place?
Well,
they use it on their own land?
The law of California is now that they may transfer and that they may maintain their legal rights in so doing, subject to a lot of constraints. It's subject to third-party impact concerns, possibly environmental concerns. Depending on the kind of water right it is, it may be subject to regulatory oversight. In some cases, it may not be. We have a little case going on now. A landowner with whom we're working in the Tule River watershed in the Southern Sierra wants to dedicate some of his water to in-stream use. Just essentially give it to the stream. So we petitioned the water board with him to have the water board approve that use. A lot of his neighbors didn't like it. They were worried about what was this going to mean. And the water board went back and very complicated analysis of his use rights over, actually his wife's use rights. I mean, she was the technical owner over I mean, the property has gone back nearly 100 years, the so-called pre-1914 rights, and decided there wasn't sufficient evidence of continuous use to approve the dedication to an environmental purpose. I mean, we have it on appeal to the water board as a whole. We'll see how they deal with it. Michael.
Well, if the people of the state own the water and you get into this transfer approach, and obviously with more people in the state, the price of water goes up. And the people own the water of the state according to the Constitution. Why should the water right holder get all the money?
Well, that's a good question. I don't know if you all heard it. Why should the water right holder get the money in a transfer scenario? The practical answer to that is to encourage the water right holder to lease or sell.
Well, that's why Jack Welch said that I'm not going to say the CEO because he's going to get quality people to make these decisions.
Well, I don't know if maybe that's close, but the issue is a fair one, and I think the Imperial situation is a very good example of that. Technically, the ownership of well, let me not use that word loosely. The legal right to the Imperial Irrigation District's portion of California's supply is in the landowners. And it appears that the district holds those rights in trust for the landowners. So under California law, there is at least a good argument that the landowners have the right to cut the deal with the other districts effectively rather than IID itself. And some of them are making that claim. Now, some of those who are making that claim are also proposing to allocate significant parts of what would be the purchase price from San Diego for both environmental remediation and for socioeconomic impact remediation. You know, farm workers who lose their jobs, local economic development that's reduced. And the sort of broader answer to both of your questions is that we're in a world of not blacks and whites, but grays, and there's going to be some interest in having rights that are vested enough to encourage transfers, but other mechanisms to assure that those who are potentially adversely affected by those transfers get some consideration. Yes?
It seems to me that in regard to water and watershed, of course, we have these traditions and the rules and the rights which were set in place after 1850. But there are traditions which go far beyond. Our memory stops at a convenient place where we have the rights. But the rights to water is, I believe, given by the state for beneficial use in a usufructuary sense. That is, a person or a group or corporation wants to use the water for certain beneficial purposes, agriculture, other use, whatever. And then the water permit is given for that particular purpose. And the person does not use it for the particular purpose. The rationale is that it will go back to the state.
Yes, and that was, of course, the dominant legal paradigm for many years, for decades, for centuries perhaps. But the economically inefficient aspect of that is that if I'm a landowner with that restriction on my right, I'm going to find inefficient and perhaps even stupid uses for my water just to maintain the right. And it is very expensive, although legally possible, for the state to take that right away from me, but practically speaking, that doesn't happen, or happens very, very rarely, only in very dramatic situations. Metropolitan Water District did in fact, well, they didn't. Some of the landowners, this is in the 80s, did in fact go after the IID for wasting water Why? Because their lands were being flooded by the Salton Sea's rise. So there have been a couple of significant cases where overuse of water has been challenged. But in general, that's hard to do. So pragmatically, the alternative, which the legislature has codified in many series of laws in the last 20 years or so, has been to switch the priorities, basically to say, you may change your use, you may change your point of diversion perhaps, you can move your right to someone else at a different place, provided there aren't adverse effects to other users or the environment, in order to make a more efficient use of a limited resource.
In that case, what it transpires is that water transfers and marketing at local levels in a small scale can be very valuable as a way of managing things locally. But then, because of the nature's limitations and the natural resources about water, we cannot give any person a right to water in perpetuity. And so what it essentially says, you can give somebody a water use permit for the next 40 years or 50 years. But if in the next 40 years or 50 years, the natural conditions could change, that the nature of the resource may be totally altered, that we cannot give that right. Or that you can find, like happened in Mono Lake or someplace, some very drastic consequences, which we cannot let happen. Both of these are beyond the ability of modern science to predict.
Well, the latter one I'll agree with, that effectively the public trust, environmental interest in Mono Lake and the Mono Basin trumped the vested perpetual right of Los Angeles. The general point that rights should not be in perpetuity, I don't know. I mean, you know, Hong Kong had a 99-year lease, right? So that was finite, but everywhere else, it's, you know, I own my land for time immemorial till I want to sell it, right?
But owning a piece of property, this is one difference which I think Professor Sachs would write about, is that owning a piece of property or land is different from owning an interest in water. That's a very fundamental. So you cannot bring the case of a land.
Well, but why? Why should it be?
Because water flows.
Yeah, so your right is subject to the flow. If climate change changes the regime of a stream, then the historic priority system applies, and the
water is a vital natural resource for everybody to sustain.
Well, that's a good argument. I agree with that.
Right now, as it will.
Yes, in the back.
I might be loud enough to softball here, but strictly
I like softballs.
the state's grant of rights to divert water from streams has some similarities to the state's grant of a right to people to discharge pollutants to its waters. And I'd ask you to address, do you think the state has been, or who do you think holds the right, the property right, is similar to the capacity of the state's waters? Has the state been donating that right to people at the low market rates? And if so, should it continue?
That's a good set of questions, and do I have another hour? Short answer, I would say, is this, that for many years, streams were free garbage pits, you know, aquatic garbage dumping areas. And over time, we have constructed state and federal laws to constrain that. And there are the dominant sort of legal approaches to the polluter are two. One is to permit pollution only with restrictions. That is to say, you, Standard Oil, or you, mom and pop metal shop, can release to the sewer system or to the bay or whatever, but only if your effluent doesn't contain more than X amounts of this pollutant and Y amount of that pollutant. And there's a very elaborate regulatory scheme that enforces that. And then in addition, there's a whole set of public subsidies to sewage treatment to have public agencies and invest in cleanup. But then the interesting question, and we aren't very far along in water pollution control in this area, is what if this permit system isn't adequate? You still have impaired water bodies. That's often a problem with so-called non-point sources, sort of runoff from streets or from farms or forests, where permitting systems are at best cumbersome, possibly almost sort of prohibitively expensive. So you really have troubles there, but then you don't have solutions. So ultimately, if it's important enough to the society to clean up the stream, you have to spend a lot of public money to get there. Or you could, close down the timber industry or close down the agricultural industry. There's a current effort actually to finally regulate farms in California for water pollution. They're exempt at the federal level from the Clean Water Act. They're not exempt technically, legally, in state law, but the Water Board has approved essentially an extension of a permit to pollute with which had no sort of time limit. The time ended, last week, and they renewed it for another couple of years and said they're trying to see what they could do. I mean, farmers have a lot of political clout, in case I've made that point already. Yes?
Tonight you restricted your remarks only to water issues, but environmental defense is interested in things like air pollution, urban sprawl.
Yes, yeah. Okay, go ahead. Sure.
If we follow through the logical conclusion of water trading, given that so much of our water goes to low economic value crops, that will free up water for urban development and urban sprawl, which will feed into all the things that environmental defense fears. So how do you feel about removing the last restriction for growth?
I don't think that's accurate. Yes, it's a problem. No, I don't think it's the last restriction on growth. It is a good point and one that has troubled us, but the reality is that people have moved into areas that have very limited water supplies even before the supply is there. I mean, arguably, I think Professor Ron Roby started his remarks with this comment that water is in the mountains and in the north, the people are on the coast and in the south, and we figured out ways to get the water to them. Often the people got there first. If you look at Mexico, northern Mexico, I mentioned it only briefly in the context of the Delta and the Salton Sea, but you have major populations on the border with very little in the way of water, and the people keep moving up there because the jobs are there. Having said all that, one needs to address the sprawl issues in other mechanisms. I mean, that's basically how we come out. The alternative is to say, the alternative is that the developers and the politicians who work with them will build dams. Yes, sir.
You mentioned the federalism of the states' rights principle established in the U.S. versus California. It seems to me that's not likely to turn out to be an unalloyed good from an environmental point of view. I mean, it may be from California's point of view because California often has stronger environmental protections than the federal government, but California is really something of an outlier in that respect. Particularly, it seems to me, when it comes to water law, there are problems such as the failure of a lot of states to recognize in-stream uses as beneficial uses. Putting state law in that stronger position is likely to impair environmental protection as often as to help.
For those of you who didn't hear the question, isn't states' rights a mixed bag? Sometimes it's good for the environment, sometimes it's not. Yes, is my answer. I'll give you one fun example. America's most distinguished constitutional law scholar, perhaps, is Larry Tribe. And Larry, this is not a water example, it's an energy example. He was the attorney for environmental interests in the days when the anti-nuclear laws were passed in California to, anti-nuclear is a shorthand, but to place significant restrictions on nuclear power development that the federal government contested. And Tribe took the case all the way to the Supreme Court. State law prevailed. The old Warren-Alquist Act from the mid-1970s has basically prevented new nuclear power plants from being built in California. Just in the last 2 years, Larry Tribe was hired by PG&E in the bankruptcy case and is arguing the exact opposite, that federal bankruptcy law should overturn state law, and PG&E should be able to take its assets and run from state regulation. So, yeah, it depends on whose ox is being gored. But I agree with the point. It's one troubling to me. I mean, an environmentalist who works in California, generally speaking, even in a Reagan era, Duke Majan era, Wilson era, is better off than one who works, say, in Mississippi or Wyoming.
Well, Mississippi didn't have public trust.
Well, it's past 7 o'clock. We are most thankful to Mr. Graff for an excellent, stimulating talk today. Thank you.
Thank you.